Part 13, Realm and Commonwealth by Stephen Spiers. Copyright 2018. In 1927, the United Kingdom of Great Britain and Northern Ireland became out of the styles and parliamentary titles in the Parliament of the United Kingdom of Great Britain and Ireland, although George V had divided Great Britain from Ireland in royal style and titles 1927. This was followed by financial agreements between the 6 states of the Commonwealth and the Commonwealth of Australia Act by referendum of the people on a referendum on state debts. Reasonably straightforward, Clause 3 allows for the Queen of the United Kingdom of Great Britain and Ireland, as already discovered through the preamble, along with Clause 1 and 2 of the Constitution Act and Letters Patent 1900. This is then backed up by the Acts Interpretation Act 1966, still demonstrating the existence of said kingdom. The Queen takes advice from the Privy Council as to the sovereignty of this Commonwealth being created. As it picks up the authorised King James Bible, and by it takes God's blessing by his will, the Privy Council ensures that the Constitution hereby attached to the Constitution Act at Clause 9 adheres to the Word of God. And when first settled and proclaimed on the 25th of October 1786, the lands to the 135th parallel to be New South Wales, the colony of the Swan River in turn became Western Australia. Western Australia was born as its own colony, whereas New South Wales was divided into what is the states. We are also told that we are a federal commonwealth, having the name Commonwealth of Australia. It is also in this clause wherein the Queen is given permission to, after proclaiming by the Constitution Act the Commonwealth of Australia, constitute the office of Governor-General by appointment. This is covered by Letters Patent 1900, wherein the instructions and rules for the office of Governor-General are set down and the office constituted. The created office was then filled by appointment. Commonwealth of Australia Constitution Act Clause 5, Operation of the Constitution and Laws. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state, and the laws of the Commonwealth shall be in force on all British ships, the Queen's ships of war excepted, whose first port of clearance and whose port of destination are in the Commonwealth. As we have investigated, the Statute of Westminster Adoption Act 1942 adopted Clause 4 of the Statute of Westminster Act 1931 UK, giving the Parliament of the Commonwealth of Australia under Bob Hawke the ability to make request for consent from the United Kingdom of Great Britain and Northern Ireland in respect to legislation post-World War II, when then Prime Minister Robert Menzies used the Act in retrospect of declarations of war on behalf of the Commonwealth of Australia, separated at the Imperial Conference of 1926. This is an interesting section of the Act, as at the time when Robert Menzies was making declarations of war, the requirement was relative to Her Majesty's ships of war and the definition of British possessions in relation to vessels in Commonwealth waters. At the time Bob Hawke is going through request and consent for the Australia Act 1986, the Office of Governor-General has been reconstituted, removing the title of Commander-in-Chief from the Office of Governor-General. The Australia Act 1986 started with requests from the states, which, as we've shown, have been under authority different to that of the Constitution Act, the Constitution and Letters Patent 1900. Here we have a clause that defines the authority of the Constitution at Clause 9 of the same, being bound on the courts, judges and people of every state and on every part of the Commonwealth, notwithstanding any laws of any state. Yet we have a separation of powers between the Commonwealth and the states. Commonwealth of Australia Constitution Act Clause 6, Definitions. The Commonwealth shall mean the Commonwealth of Australia as established under this Act. The states shall mean such of the colonies of New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia, and South Australia, including the Northern Territory of South Australia, as for the time being are parts of the Commonwealth, and such colonies or territories as may be admitted into or established by the Commonwealth as states, and each of such parts of the Commonwealth shall be called a state. Original states shall mean such states as are part of the Commonwealth at its establishment. Commonwealth of Australia Constitution Act Clause 8. Application of Colonial Boundaries Act. After the passing of this Act, the Colonial Boundaries Act 1895 shall not apply to any colony which becomes a state of the Commonwealth, but the Commonwealth shall be taken to be a self-governing colony for the purposes of that Act. As you can see by looking at the Commonwealth of Australia Constitution Act July 1900 UK PGA, the states no longer have their statuses as colonies, and as at July 1900 New Zealand was then considered a colony and a relative state of the Commonwealth of Australia. In the wording original states, we can see that Queen Victoria's wording expedient meant new states. In becoming states, the former colonies of the British Empire forgave their colonial boundaries as well, and when we reflect back on Clause 5 of the Constitution Act, we see that the Commonwealth has judicial authority over the former colonies. It is an important fact to point out, that the state have lost their boundaries in which they have relied so heavily on, and through births, deaths, and marriages, and the enforcement of state legislation, have forgotten about their parent authority in the Constitution Act and its links to the United Kingdom of Great Britain and Ireland, the imperial crown, and the blessing of Almighty God in self-determination at the spilling of blood of Anzac. Commonwealth of Australia Constitution Act Clause 7. Repeal of Federal Council Act. The Federal Council of Australasia Act 1885 is hereby repealed, but so as not to affect any laws passed by the Federal Council of Australasia and in force at the establishment of the Commonwealth. Any such law may be repealed as to any state by the Parliament of the Commonwealth, or as to any colony not being a state by the Parliament thereof. It is interesting to note at Clause 7 of the Commonwealth of Australia Constitution Act July 1900 UK/PGA that in the repeal of the Federal Council Act, a body that was put together to oversee the formation and debates of federation, that the Constitution Act declares that a colony, should it not become a state of the Commonwealth of Australia, may still repeal any acts relevant to the Federal Council Act. A question is raised here in the installation of the Australia Act 1986 and its requests from the states to the Commonwealth in 1985 relative to severing from the United Kingdom. A state was never under the United Kingdom of Great Britain and Ireland under Commonwealth of Australia Constitution Act 1900, July 1900 UK PGA and Letters Patent 1900 of Queen Victoria. It was very clear that the former colonies had their borders repealed and that in becoming states they were under the Commonwealth of Australia. Constitution Act Clause 9 of the Commonwealth of Australia Constitution Act July 1900 UK PGA, a very important fact that cannot be ignored. At Clause 5 of the Commonwealth of Australia Constitution Act July 1900 UK/PGA, the states have a defined line of authority in its judicial systems, which ties directly to their parliaments and their requirements as states of the Commonwealth of Australia to adhere to that line of authority. In Letters Patent 1900, it is clear that the Governor-General is appointed along with the Great Seal of the Commonwealth of Australia under the United Kingdom of Great Britain and Ireland, which at the beginning of this paper has been defined very clearly becoming the birthright of the people of the Commonwealth of Australia as detailed in the Act of Settlement 1700. We have looked briefly at the Oath of Allegiance and the Oath of Office of Quentin Bryce, as she took office as Governor-General of the Commonwealth of Australia, and seen that the wording is in accordance with the schedule to the Constitution at Clause 9 of the Commonwealth of Australia Constitution Act July 1900 UK/PGA, but alas, it is not in accordance with Letters Patent 1900 and the Imperial Crown. We have also seen how through the tenure of Gough Whitlam as Prime Minister of the Commonwealth of Australia, the Parliament of the Commonwealth of Australia was reformed as the Australian Government, along with a change of allegiance, oaths, and national anthem in 1973. As we move forward, we look at Governor-General of Australia Peter Cosgrove and former head of the Australian Defence Force. We can see initially by the commission issued in the Commonwealth of Australia Gazette that under Royal Sign Manual and the Great Seal of Australia first created in 1973 during the whole sweeping change involving your allegiance. We also saw how the Great Seal of Australia became a seal with royal powers outside of its initial issues powers over this newly formed Australia, including its own honours roll in the Order of Australia. Commonwealth of Australia Gazette, published by the Commonwealth of Australia, Government Notices, signed Elizabeth R. Commission, passed under the Royal Sign Manual and the Great Seal of Australia, appointing General Peter John Cosgrove, ACMC, Reed, to be the Governor-General of the Commonwealth of Australia. Elizabeth II, by the grace of God, Queen of Australia and her other realms and territories, head of the Commonwealth, to Peter John Cosgrove, Companion of the Order of Australia, Military Cross, greeting. Commonwealth of Australia Gazette, published by the Commonwealth of Australia, Government Notices. Proclamation. Whereas Her Majesty Queen Elizabeth II has been graciously pleased by commission under her Royal Sign Manual and the Great Seal of Australia, dated 12 March 2014, to appoint me, Peter John Cosgrove, Knight of the Order of Australia, Companion in the Military Division of the Order of Australia, Military Cross, to be Governor-General of the Commonwealth of Australia. Now, therefore, I proclaim that I have this day made the prescribed oath of allegiance and the prescribed oath of office of the Governor-General of the Commonwealth of Australia before the Honourable the Chief Justice of Australia, and that I have assumed the office accordingly. Signed and sealed with the Great Seal of Australia on 28 March 2014, Governor-General, by His Excellency's command, Prime Minister. Government Notices Gazette, C 2014 G00548 01/04/2014. We do, by this our Commission, under our Sign Manual and the Great Seal of Australia, appoint you, Peter John Cosgrove, to be, during our pleasure, our Governor-General of the Commonwealth of Australia. And we do authorise, empower and command you to exercise and perform all and singular the powers and directions contained in the Letters Patent dated 21 August 2008, relating to the office of Governor-General, or in future Letters Patent relating to that office, according to such instructions as our Governor-General for the time being may have received or may in the future receive from us, and according to such laws as are from time to time in force. And we do declare that the powers conferred by this our Commission include any further powers that may in future be assigned to the Governor-General in accordance with Section 2 of the Constitution of the Commonwealth of Australia, given at our court at St. James on 12 March 2014, by Her Majesty's command. Prime Minister. Government Notices Gazette, C 2014 G00545 01/04/2014. What you begin to see here is that the Governor-General is appointed under Letters Patent 2008, which replaced Letters Patent 1984, in which the office of Commander-in-Chief of the Defence Forces was removed from the office of the Governor-General. In the Commission, we can see that Queen Elizabeth II has taken to the office of Queen of Australia, using the Great Seal of Australia as her royal seal to the Commission. In the proclamation that follows, Peter Cosgrove, from the office of Governor-General, proclaims that he is the Governor-General of the Commonwealth of Australia under Queen Elizabeth II's Royal Sign Manual and the Great Seal of Australia, acting as a royal seal under the St. Edward's Crown. In this page following the proclamation from the ministers in government under their sign manual and the Great Seal of Australia, now being used in standard capacity and not as a royal seal, authorise and empower and command Peter Cosgrove to perform all this powers and directions contained in Letters Patent 2008. Given the direct conflict to Letters Patent 1900 and the constitution of the Office of Governor-General under Queen Victoria's command, the Governor-General of the Commonwealth of Australia is in allegiance to Queen Elizabeth II, Queen of Australia, loyal to the allegiance set out in the documents under secret meetings with the Queen in 1973. We cannot ignore either the fact that the Australia Act 1986 came out of the adoption of Clause 4 of the Statute of Westminster 1931 during a declaration of warfare post-Imperial Conference 1926. Peter Cosgrove, as head of the Australian Defence Force, or ADF, before taking on the position as head of the Australia, directly responsible to Queen Elizabeth II as Queen of Australia, head of the Commonwealth of British Nations. Yet here we have the Governor-General carrying the title of Governor-General of the Commonwealth of Australia in contradiction of Letters Patent 1900. Considering that self-determination of the Commonwealth of Australia within the realm of the Imperial Crown was proclaimed by Prime Minister Billy Hughes, standing and speaking on behalf of 60,000 dead during the Treaty of Versailles in 1919, and linking with the League of Nations, how did the Australian Imperial Forces turn Commonwealth of Australia Defence Forces turn into Australian Defence Forces? Anybody that has joined the military knows they take their oath of allegiance. They are now fighting for the realms in which they are led to believe they are fighting. Are Australians fighting for an allegiance to a constitution with its laws and duties, or are they fighting for the freedoms under God to a realm in which they were allowed to be free? As we work through this paper, we start to see that the Commonwealth of Australia is not all that it seems on the surface. In the years, there have been some rather serious changes to the Commonwealth of Australia. Noticed by the legal fraternities throughout the Commonwealth of Australia, it was barely noticed by the population. Over time, it ground down on the populace until it started to be noticed. Police became more militarised. Councils took on local governance, state fractured from federal jurisdictional roots. Impact on the finances of the populace is where it is most noticed. Yet, they are all in a slumber, glued to the televisions in a belief that the parliamentary system will fix the issues of their lives. What if that parliamentary system was designed to take use of your fruits instead of nurture them? 74. Article 5 reads as followed. 1. A successor state shall grant its nationality to persons who, at the time of the state's succession, had the nationality of the predecessor state, and who have or would become stateless as a result of the state's succession, if at that time A. They were habitually resident in the territory which had become territory of the successor state, or B. They were not habitually resident in any state concerned, but had an appropriate connection with the successor state. 2. For the purpose of paragraph 1, subparagraph B, an appropriate connection includes, inter alia, A legal bond to a territorial unit of a predecessor state, which has become territory of the successor state. B. Birth on the territory, which has become territory of the successor state. C. Last habitual residence on the territory of the predecessor state, which has become territory of the successor state. Article 6 establishes that a predecessor state shall not be withdrawn its nationality from its nationals who have not acquitted the nationality of the successor state, and who otherwise become stateless as a result of the state succession. The Changing Role of Nationality in International Law, edited by Serena Forlati, Alexandra Anoni. We can see by the growth in the studies in international law that this problem isn't just that of the Commonwealth of Australia and its realm. This has extended its hand out over the last 2 centuries to envelop the world. Now we have a system of nation states observing the passage of persons between those nation states, with agreements on nationality being severed only after the acquiring nationality in a successor state. Instead, being bound to the realms of God, the people of the world are now bound to the laws and duties of the constitutions of their nation states. The implications of this are vast and outside of the boundaries of this white paper. What we have observed, though, is that most of the changes that have occurred throughout the history of the Commonwealth of Australia that are of any importance to the changes over time are related to the monarchy, the generals, be they Governor Generals, Attorney Generals, Solicitor General, or the actions relating to defining the line of authority to the monarchy through declarations of warfare. Floating jetsam in a highly volatile worldwide situation post World War I and the declarations of warfare in 1939 put the Commonwealth of Australia in a precarious position related to its defence. To give its power back to the United Kingdom and the King as head of the realm to enter a war in a Commonwealth of British nations, considering enactment of the Statute of Westminster 1942 in retrospect of the Statute of Westminster 1931, in declarations of war against Germany in 1939, are key to the centre of the problems associated with the realm. We have to go through a bit of history of the United Kingdom of Great Britain and Ireland to start to answer these questions. The United Kingdom of Great Britain and Ireland didn't exist before 1801. Prior to this being Great Britain, a union of Scotland and England declared on 1 May 1707. Now in union with the Kingdom of Ireland, the United Kingdom of Great Britain and Ireland through the Union of the Crowns. It is evident through the start of this white paper that we have defined the United Kingdom of Great Britain and Ireland to be Queen Victoria's legacy. Through historical record, we have defined the realm of the United Kingdom of Great Britain and Ireland to fly the royal ensign showing angel on harp with back sweeping wings, also displayed atop Old Parliament House, defining the royal law to which the Commonwealth of Australia finds the roots of its authority, being the authorised King James Bible, being the laws of England set down as a birthright in the Acts of Settlement 1700. We can see by the coats of arms on the acts associated with Her Majesty's wastelands, being the territory originally of New South Wales, yet transferred to South Australia and under the governance of the colony of South Australia at the time of constitution into a state. When the Northern Territory is transferred into Federal Territory in 1907, we can see that the royal arms of Edward VII have not changed. What follows through other legislation, which is shown here in the last image, is a total change to the Commonwealth of Australia coat of arms issued in 1912, which is then stylised with versions registered in the US Patent and Trademark Offices. If we observe the Commonwealth of Australia Gazette, we notice that the coat of arms begins to change rather obviously in May 1925, followed by another large change in June of 1925, then further stylised on the coat of arms. We also notice the involvement of the United Nations technically before its inception, born from the League of Nations, with Prime Minister Billy Hughes signing into the League of Nations in 1919. The question is, did he hamper the sovereignty of the Commonwealth of Australia, or did he entrust it in a league of extraordinary gentlemen? Let's go back a little in history to a time of American independence. The United Kingdom of Great Britain and Ireland had, under the auspices of William Wilberforce, finally abolished slavery in the involuntary sense of the word at law. The Civil War in the Americas saw Abraham Lincoln sweep across the United States of America, taking Confederate states and bringing the continental structure into the trust of the United States Incorporated and given power by Congress in 1871. Previous to this, the United States of America had sealed a Declaration of Independence from outside realms in 1776, pushing the British away from the coast after a reasonably lengthy battle. The national anthem of the United States of America was coined as the Star-Spangled Banner, seeing the largest United States flag fly from the shoreline in America's history. Copies of the original flag, still in their mammoth size, still fly on the shores of the United States today. This saw the United Kingdom go to treaty, resulting in the Treaty of Ghent, wherein it displayed promise not to attack the United States of America by declaration again, self-determination of a declared independent nation under a republican-style Congress instead of a principality-style monarchy. This followed the Treaty of Paris in 1786, where several large world bodies made peace treaty, including the United States of America. This would frame the world stage for a century or more. We include full documents here so that you can get a full picture of what happened within the world stage leading up to the last century, or modern history they failed to teach correctly in schools. Treaty of Peace and Amity between His Britannic Majesty and the United States of America. His Britannic Majesty and the United States of America, desirous of terminating the war which has unhappily subsisted between the two countries, and of restoring upon principles of perfect reciprocity, peace, friendship, and good understanding between them, have for that purpose appointed their respective plenipotentiaries, that is to say, His Britannic Majesty, on his part, has appointed the Right Honourable James Lord Gambier, late Admiral of the White, now Admiral of the Red Squadron of His Majesty's fleet, Henry Goulburn, Esquire, a member of the Imperial Parliament and Under Secretary of State, and William Adams, Esquire, Doctor of Civil Laws, and the President of the United States, by and with the advice and consent of the Senate thereof, has appointed John Quincy Adams, James A. Bayard, Henry Clay, Jonathan Russell, and Albert Gallatin, citizens of the United States, who, after the reciprocal communication of their respective full powers, have agreed upon the following articles. Article the First. There shall be a firm and universal peace between His Britannic Majesty and the United States, and between their respective countries, territories, cities, towns, and people of every degree, without exception of place or persons. All hostilities, both by sea and land, shall cease as soon as this treaty shall have been ratified by both parties, as hereinafter mentioned. All territory, places, and possessions whatsoever taken by either party from the other during the war, or which may be taken after the signing of this treaty, exempting only the islands hereinafter mentioned, shall be restored without delay and without causing any destruction or carrying away any of the artillery or other public property originally captured in the said forts or places, and which shall remain therein upon the exchange of the ratifications of this treaty, or any slaves or other private property. and all archives, records, deeds, and papers, either of a public nature or belonging to private persons, which in the course of the war may have fallen into the hands of the officers of either party, shall be, as far as may be practicable, forthwith restored and delivered to the proper authorities and persons to whom they respectively belong, such as the islands in the Bay of Passamaquoddy, as are claimed by both parties, shall remain in the possession of the party in whose occupation they may be at the time of the exchange of the ratification of this treaty, until the decision respecting the title to the said islands shall have been made in conformity with the fourth article of this treaty. No disposition made by this treaty as to such possession of the islands and territories claimed by both parties shall in any manner whatsoever be construed to affect the right of either. Article the Second. Immediately after the ratifications of this treaty by both parties, as hereinafter mentioned, orders shall be sent to the armies, squadrons, officers, subjects, and citizens of the two powers to cease from all hostilities, and to prevent all causes of complaint which might arise on account of the prizes which may be taken at sea after the said ratifications of this treaty. It is reciprocally agreed that all vessels and effects which may be taken after the space of 12 days from the said ratifications upon all parts of the coast of North America, from the latitude of 23 degrees north to the latitude of 50 degrees north, and as far eastward in the Atlantic Ocean as the 36th degree of west longitude from the meridian of Greenwich, shall be restored on each side, that the time shall be 30 days in all other parts of the Atlantic Ocean north of the equinoctial line or equator, and the same time for the British and Irish channels, for the Gulf of Mexico and all parts of the West Indies, 40 days for the North Sea, for the Baltic, and for all parts of the Mediterranean, 60 days for the Atlantic Ocean south of the equator as far as the latitude of the Cape of Good Hope, 90 days for every other part of the world south of the equator, 120 days for all other parts of the world without exception. Article the Third. All prisoners of war taken on either side, as well by land as by sea, shall be restored as soon as practicable after the ratifications of this treaty as hereinafter mentioned, on by paying the debts which they may have contracted during their captivity. The two contracting parties respectively engage to discharge in specie the advances which may have been made by the other for the sustenance and maintenance of such prisoners. Article the Fourth. Whereas it was stipulated by the second article in the Treaty of Peace of 1783 between His Britannic Majesty and the United States of America that the boundary of the United States should comprehend all islands within 20 leagues of any part of the shore of the United States and lying between lines to be drawn due east from the points where the aforesaid boundaries between Nova Scotia on the one part and East Florida on the other shall respectively touch the Bay of Fundy and the Atlantic Ocean, excepting such islands as now are or heretofore have been within the limits of Nova Scotia, and whereas the several islands in the Bay of Passamaquoddy, which is part of the Bay of Fundy, and the island of Grand Menan, in which is said Bay of Fundy, are claimed by the United States as being comprehended within their aforesaid boundaries, which said islands are claimed as belonging to His Britannic Majesty, as having been at the time of and previous to the aforesaid treaty of 1783 within the limits of the province of Nova Scotia. In order, therefore, finally to decide upon these claims, it is agreed that they shall be referred to 2 commissioners to be appointed in the following manner, viz. 1 commissioner shall be appointed by His Britannic Majesty, and 1 by the President of the United States, by and with the advice and consent of the Senate thereof. And the said 2 commissioners so appointed shall be sworn impartially to examine and decide upon the said claims according to such evidence as shall be laid before them on the part of His Britannic Majesty and of the United States respectively. The said commissioners shall meet at St. Andrews in the province of New Brunswick, and shall have powers to adjourn to such other places or places as they shall think fit. The said commissioners shall, by a declaration or report under their hands and seals, decide to which of the 2 contracting parties the several islands aforesaid do respectively belong, in conformity with the true intent of the said Treaty of Peace of 1783. And if the said commissioners shall agree in their decision, both parties shall consider such decisions as final and conclusive. It is further agreed that in the event of the 2 commissioners differing upon all or any of the matters so referred to them, or in the event of both or either of the said commissioners refusing or declining or wilfully admitting to act as such, they shall make jointly or separately a report or reports as well to the government of His Britannic Majesty as to that of the United States, stating in detail the points on which they differ, and the grounds upon which their respective opinions have been formed, or the grounds upon which they or either of them have so refused, declined, or omitted to act. And His Britannic Majesty and the Government of the United States hereby agree to refer the report or reports of the said commissioners to some friendly sovereign or state to be then named for that purpose, and who shall be requested to decide on the differences which may be stated in the said report or reports, or upon the report of 1 commissioner, together with the grounds upon which the other commissioner shall have refused, declined, or omitted to act, as the case may be. And if the commissioner, so refusing, declining, or omitting to act, shall also wilfully omit to state the grounds upon which he has so done, in such a manner that the said statement may be referred to such friendly sovereign or state together with the report of such other commissioner, then such sovereign or state shall decide ex parte upon the said report alone, and His Britannic Majesty and the Government of the United States engage to consider the decision of such friendly sovereign or state to be final and conclusive on all the matters so referred. Article the 5th. Whereas neither that point of the Highlands lying due north from the source of the river St. Croix, and designated in the former Treaty of Peace, Paris, between the 2 powers as the northwest angle of Nova Scotia, nor the northwesternmost head of the Connecticut River, has yet been ascertained, and whereas that part of the boundary line between the dominions of the 2 powers, which extends from the source of the river St. Croix directly north to the above-mentioned north-west angle of Nova Scotia, thence along the said highlands, which divide those rivers that empty themselves into the river St. Lawrence from those which fall into the Atlantic Ocean, to the north-westernmost head of the Connecticut River, thence down along the middle of that river to the 45th degree of the north latitude, thence by a line due west on said latitude until it strikes the river Iroquois or Carataquois, has not yet been surveyed. It is agreed that from these several proposers 2 commissioners shall be appointed, sworn and authorized to act exactly in the manner directed with respect to those mentioned in the next preceding article, unless otherwise specified in the present article. Then said commissioners shall meet at St. Andrews in the province of New Brunswick, and shall have powers to adjourn to such other place or places as they shall think fit. The said Commissioners shall have power to ascertain and determine the points above mentioned in conformity with the provisions of the said Treaty of Peace, Paris, of 1783, and shall cause the boundary aforesaid from the source of the river St. Croix to the river Iroquois or Catequay to be surveyed and marked according to the said provisions. The said Commissioners shall make a map of the said boundary and annex to it a declaration under their hands and seals certifying it to be the true map of the said boundary, and particularizing the latitude and longitude of the northwest angle of Nova Scotia, of the northwesternmost head of Connecticut River, and of such other points of the said boundary as they may deem proper. And both parties agree to consider such map and declarations as finally and conclusively fixing the said boundary. And in the event of the said two Commissioners differing, or both or either of them refusing, declining, or wilfully omitting to act, such reports, declarations, or statements shall be made by them or either of them, and such reference to a friendly sovereign or state shall be made in all respects as to the latter part of the fourth article is contained, and in as full a manner as if the same was herein repeated.